What factors are considered when deciding if we have to go through probate? My name is Philip Bruce. I'm an estate planning attorney in Minnesota, and not every estate goes through probate. The three things that force it are the three things we need to fix if we want to avoid the probate process. Probate, again, is the administrative court proceeding where if I die, my stuff gets divided up. We need someone who can be in charge, who can sell my house, who can pay my bills. That ability to sign on behalf of the estate comes from a judge by default. It's fixable. But the three things that are going to force the issue are, number one, real estate that is or will one day be owned by just one person. I die and I own my house jointly with my wife. She's the joint owner. As the joint owner, she gets it. Good. We don't need court. But now the house is in her name only because I'm gone. So now it's just her house. When she goes, absent other planning, we are going to have to go to court and get that retitled to wherever it's supposed to go. If you don't have any documents, you use Minnesota's backup rules. Those don't make a lot of sense. You should at the minimum have a probate court controlling document to tell the court where it should go. That's what a will is. A will goes through probate. It controls court. Okay. So the first one is real estate. If you have real estate, if it will one day be owned by just one person, everyone has a probate in front of them, absent some other planning. It's fixable. The second reason, let's say, so pay on death beneficiaries on your various accounts, your life insurance, IRAs, 401ks, bank accounts. Those things, as long as they name an adult, those things skip probate. You can't do a lot of backups. You can't say to my adult child, and if something happens to them, it goes to their kids and not to their spouse. You can't do any of that stuff. But if you just want to say, hey, here you go, good luck, hope things turn out with this money, you just name your adult kids or adult grandkids or adult siblings or whoever it is. That will avoid probate. That's great. But let's say you didn't do that. We have to take the full amount of the estate that is subject to probate. So ignore the real estate for a second. Let's say we fix the real estate. Let's not count the house. If I have a $20,000 car, and if I have a $10,000 bank account, and I never added beneficiaries to it, these two things are now subject to probate. But I have some leeway. I have some grace. This dollar amount changes periodically. As I'm recording this video, it's $75,000. If I'm less than $75,000, I'm in the clear. If I have a $50,000 car and a $50,000 savings account and I never added beneficiaries to that savings account, I'm at 100. Those two things for sure are going to have to go to court to get retitled. It's the aggregate total. That's the important thing. So when we talk about revocable trust planning, I'm going to get my house, which is a probate thing, and I'm going to get it in my family entity. And now that's not going to go through probate. I might name the trust as the pay on death beneficiary of my accounts. You can name people, but maybe I name this instead. That's okay, whatever. Anything that ends up in this thing, no probate. If I forget a couple things, car, boat, ATVs, maybe a bank account or two, we just have to add up the value of those. If the aggregate value is more than $75,000 per person, we will need probate. So number one, real estate that is owned by just one person. Number two, too much stuff. And the third reason is something about the will document. We're talking about probate, which means we're talking about wills. Something about the probate document itself, the will document, needs a judge's signature. The two big things are when we're creating a trust for children to create some rules on their inheritance, that requires a judge's signature to become real. The trust is technically effective right away, but there aren't a lot of financial institutions who are going to take your word for it. They're going to want to make sure that that really is your will. Did I really sign it? Was I under duress? Did I amend it? Did I revoke it? Etc. We need a judge to determine that. And then lastly, charitable distributions. If this gives $10,000 to the Humane Society, if my will is giving a charity, distribution to a charity, that will require probate as well. All of this is fixable. You can fix all of this. I talk about revocable trusts a lot. That's the primary tool. But those are the three reasons we go through probate. Any questions about this, shoot us an email.